Hello, I am Chief Judge Deborah Bice. It's my pleasure to welcome you to another installment of the ODAR Continuing Education Program, or OSEP. I especially want to thank those of you who have suggested topics for future OSEP broadcasts. Since our goal is to provide quality hearings and decisions, your suggestions allow us to explore subjects we may include in future legal education programs, helping to meet our goal of providing quality hearings and decisions. Today, the OSEP team will discuss vocational expert evidence. As you know, a vocational expert, or VE, provides expert testimony or responds to interrogatories to assist the judge in determining the effects of exertional and non-exertional limitation on the claimant's ability to perform past work or other work that exists in the national economy. Today's team will provide practical tips for using VE evidence in your hearings and decisions. I hope you find the information useful. Judge John Costello from our Rochester, New York hearing office has done a tremendous job in leading the OSEP planning team, which puts a great deal of work into each of these broadcasts. Thanks to all of you on the team. That said, here is Judge Costello to introduce our instructors and provide you with more information about today's topic. Judge Costello?
Thank you, Judge Bice. The topics we select for presentation are based on your recommendations. We choose those that have general appeal and have proven to be most troublesome in application. I stress the word application because it's one thing to know the law. It's another to apply it to many different situations. So we emphasize the practical. We outline the law, address common problems, and offer concrete solutions. Today's program on vocational evidence takes a nuanced approach. You should be familiar with the basic rules governing vocational evidence and the use of vocational experts. So today, we'll look at more subtle, sophisticated issues. Issues such as, when do you need a vocational expert? What do we mean by a conflict with the DOT? When are transferable skills an issue? How should cross-examination be handled? Remember the 1993 movie Philadelphia, starring Tom Hanks and Denzel Washington? Both play lawyers. There is a scene in which Tom Hanks goes into a long, discursive explanation of a legal issue to Denzel Washington. As Tom rambles, Denzel interrupts and says, "Stop. Explain it to me like I'm a 6-year-old." Figuratively speaking, that's our approach. Simply because the issues are sophisticated does not mean the discussion must be complicated or obtuse. Your time is precious. We have 1 hour to grab your attention and leave you with useful, practical advice. We aim to make the complex simple. As always, we focus our presentation on the keys. Today, the 4 keys to vocational evidence. The keys are a one-page guide to the topic and summarize the points we will make today. In addition, our website includes other materials and questions and answers from earlier programs. You'll also find today's script with hyperlinks to the law. Go to the website whenever you have a question on the topics we have presented. You can access it through a link on the ALJ website. If you have a question not answered in today's program, send it to our mailbox at @ODAR Continuing Education Program. We vet every answer with other Social Security components to ensure you get the right answer. This takes time, but we'll post as soon as possible. The management team in each office will incorporate a discussion on today's topic at a meeting, either immediately following this broadcast or soon thereafter. These meetings reinforce and clarify the points made today. We encourage you to meet as one group. Now I am pleased to introduce our speakers today. They are Leo Montenegro from the Office of the General Counsel, Administrative Law Judges Kim Griswold of the Hartford, Connecticut Hearing Office, Deborah Goldstein of the Birmingham, Alabama Hearing Office, and Administrative Appeals Judge Maine Nguyen. Judge Goldstein?
Today, we take up the subject of vocational evidence. The reason is simple. It is the linchpin of the vast majority of decisions you will write, issue, or review on appeal. Few cases are decided at the hearing level without considering vocational factors at step 4 or 5 of the sequential evaluation process. Since it plays such a prominent role, a deep understanding of the topic is critical to providing due process. Obtaining and using evidence from a vocational expert, or VE, is our primary focus today. But today's program is not a primer. Presumably, you all know the basic rules about VE evidence. Instead, we'll concentrate on more subtle issues. As always, our approach is to raise common questions and give you clear, concrete, practical answers.
We'll start with a brief overview of the sources of vocational evidence. Of course, vocational evidence is not limited to VE testimony. The regulations and Social Security rulings, or SSRs, also are a source. We'll show how administrative notice may be used to decide some cases and demonstrate why a VE is necessary in most. The overview concludes with a simple message. Administrative law judges, or ALJs, should obtain evidence from a VE in nearly every adult disability case. Many ALJs already do so. To those who do not, we'll show you why you should. VE evidence can be secured in two ways, through interrogatories or live testimony. For convenience and efficiency, most ALJs prefer live testimony. When we refer to VE evidence today, we will mean evidence from a qualified VE, obtained through live testimony or interrogatories.
As we have in all OSEP broadcasts, we center the program on a few key concepts. Today, we introduce the 4 keys to vocational evidence. They are: 1. Most adult disability cases require VE evidence. 2. No SSR 004P. Address conflicts with the DOT. 3. Transferable skills are usually not an issue. Do not assess unless necessary. And 4. Examination of the VE is limited to pertinent questions on material issues. The ALJ should determine the appropriateness of questions asked and answers given. An understanding of the keys will allow you to conduct an efficient hearing and draft a complete decision affording full due process to the claimant. Our aim is to help you to get it right the first time and avoid remands.
The burden of proof to establish disability remains with the claimant at all steps of the sequential evaluation process. However, under 20 CFR sections 404.1560 C2 and 416.960 C2, the burden of going forward with evidence shifts at step 5 to the Commissioner. At step 5, the Commissioner must show other work exists in significant numbers in the national economy that the claimant can perform. The burden can be met only through vocational evidence. So, what are the sources of vocational evidence at the hearing level? Where do you find evidence to carry the burden of going forward at step 5?
Well, there are 2 sources, the Medical Vocational Guidelines and VE evidence. The Medical Vocational Guidelines are found at Appendix 2 to Subpart P of 20 CFR Part 404. Since the guidelines are in the form of a matrix in the regulations, they're commonly referred to as the grid rules. Here, the Commissioner has taken administrative notice of the number of unskilled jobs in the national economy for an individual who can perform the full range of unskilled sedentary, light, medium, heavy, or very heavy work. The grid rules also consider the vocational factors of age, education, and work experience. If a claimant's vocational factors and residual functional capacity, or RFC, match a grid rule, the rule directs a finding of disabled or not disabled. The Medical Vocational Guidelines do not direct a decision where an individual has non-exertional limitations or an exertional capacity between 2 exertional levels. These limitations erode the occupational base of jobs that may be performed. In these circumstances, the burden at step 5 is not satisfied by reference to the grid rules alone. It's like trying to fit a square peg in a round hole. The additional limitations render a claimant's RFC a square peg. It won't fit into the round hole of the grid rules. Occasionally, the Social Security rulings, or SSRs, may be used with the medical vocational guidelines to direct a decision. In the SSRs, the Commissioner identified some basic work activities that do not significantly erode the occupational base. In some limited instances, information in the SSRs can be used in conjunction with the medical vocational guidelines to determine whether the claimant is disabled without the need for a VE. They include SSRs 8312, 8314, 8515, and 969P. We'll keep this graphic on the screen so you can copy it if you choose. A transcript of this broadcast is posted on the OSEP website with hyperlinks to the full text of each SSR listed. It's a good reference to check following the broadcast. We've also compiled a summary of the limitations discussed in the SSRs and posted it on our website. You might find this a helpful reference tool.
For example, SSR 969P says that a restriction to occasional stooping would, by itself, only minimally erode the unskilled occupational base of sedentary work. Therefore, if the claimant can only occasionally stoop, but otherwise can do sedentary work, SSR 969P allows you to use the grid rules as a framework for the decision at Step 5. Likewise, SSR 8314 states that an inability to ascend or descend scaffolds, poles, and ropes has little or no effect on the unskilled light occupational base. In each of these examples, the additional limitation is de minimis. That is a minor, non-exertional limitation that does not significantly affect the occupational base. So the grid rules with the SSR can be used to make your disability finding at Step 5. You should understand that the limitation must be specifically articulated in the SSR. You cannot extrapolate to other situations. In our example, SSR 969P discusses stooping limitations for a claimant limited to sedentary work. Its application is limited to that situation alone. If you have a claimant limited to sedentary work and occasional reaching, for example, it would not apply.
Are there other examples of de minimis additional limitations in the SSRs?
Yes, but they are few and very specific. I'll highlight the most common. Check the SSR or our website for a complete listing. For all work, the inability to kneel or crawl has a small, non-significant effect on the occupational base.
What about a claimant limited to light work?
For light work, the inability to crouch, to ascend or descend scaffolding, poles, and ropes, or a limit to occasional stooping does not significantly affect the occupational base.
For sedentary work?
For sedentary work, the following limitations do not significantly affect the occupational base: inability to crouch, occasional stooping, restrictions on the ability to push or pull, ascending or descending scaffolding, poles, and ropes, a need to avoid exposure to hazards.
As you can see, these are very narrowly defined non-exertional limitations. Seldom do you have a case that the claimant's RFC falls neatly into a grid rule with only these additional de minimis limitations. So how many cases can be decided at Step 5 using only the grid rules and SSRs? Not many, obviously. Remember, the burden of going forward at Step 5 is on the agency.
Know the medical vocational guidelines and the SSRs. Use them. They afford guidance, but they're not a panacea. If you're looking to them as a magic bullet, you're mistaken. A VE is needed to complete the administrative record and meet your burden in most cases. Failure to obtain evidence from a VE at the hearing is one of the most common reasons for remand. It's a red flag when the decision is reviewed on appeal, either at the Appeals Council or district court level. Statistics show that almost 90% of all Step 5 remands result from the failure to obtain VE evidence. So the simple advice and a good rule of thumb is this: have VE evidence at every adult disability hearing.
From the perspective of the Office of General Counsel, we couldn't agree more. The lack of VE evidence at the hearing is a primary reason for remands at the federal court level. If VE evidence is not in the record, we can't surmise what it would have shown. Courts will not ask us to interpret or argue rationale not contained within the four corners of the decision. Understandably, the courts strictly apply this rule, particularly when the burden of going forward with evidence shifts to the commissioner at step 5. The cure is simple. Get vocational evidence from a VE. Attorney advisors and paralegals occasionally must draft a decision in which VE evidence was not obtained. When a claimant has a combination of exertional and non-exertional limitations, VE evidence would help to support the findings made. Decision drafting, by necessity in this instance, must look to the grid rules and the SSRs to see if you can assert that the occupational base of available jobs is not significantly eroded. Attorney advisors and paralegals should have a good working knowledge of each of the SSRs listed to assist in drafting decisions.
To summarize, let's look to Key 1 of the 4 keys to vocational evidence. Key 1 says, most adult disability cases require VE evidence.
Let's move now to Key 2 of the 4 keys to vocational evidence. Key 2 says, no SSR 004P. Address conflicts with the DOT. SSR 004P is simple enough. It says that before relying on VE evidence to support a decision, you must identify and obtain a reasonable explanation for any conflicts between occupational evidence provided by the VE and information in the Dictionary of Occupational Titles, or DOT, including its companion publication, the Selected Characteristics of Occupations, or SCO, and you must explain in the decision how any conflict was resolved. Remember, under our regulations, you rely primarily on the DOT and its companion publication, the SCO, for information about work in the national economy. And as we just explained, you may use a VE at steps 4 and 5 to resolve complex vocational issues. The occupational evidence supplied by the VE generally will be consistent with the DOT.
ALJs, you have an affirmative duty under SSR 004P to ask about conflicts with the DOT. The last question you should ask the VE at every hearing is whether the testimony conflicts with the DOT. Alternatively, you may ask about any conflicts after each hypothetical posed to the VE. If you suspect a conflict between the testimony and the DOT, ask about it specifically. If the answer is yes, there is a conflict, ask the VE to explain the basis for the opinion that is in conflict with the DOT. You decide whether to accept the explanation. Remember, neither the DOT nor the VE evidence trumps when there is a conflict. You must decide if the explanation offered by the VE is reasonable. Can the VE testimony be relied upon rather than the DOT? Simple in theory, subtle in practice.
Conflicts may occur due to changes in the workplace over the past several decades. Occupational definitions and descriptions were formulated in the DOT some years ago. Many occupations have evolved and changed over time. Technological improvements, safety processes, or equipment advances over this time may not be accounted for in the DOT or SCO. This may result in changes to skill and exertional requirements for some occupations.
All right, now that we understand the concept, let's cover some examples of these changes and how they affect adjudication.
Let's look first at a situation where the skill level for an occupation has changed. Here's a good example, the position of switchboard operator. A switchboard operator is defined in the DOT as sedentary, semi-skilled work with a specific vocational preparation, or SVP, of 3. Many VEs now view this as unskilled work due to changes in technology and work requirements that automatically route most calls, reducing the skill level of the work. So, a VE may testify that although the DOT defines the work as semi-skilled, the VE finds it to be unskilled work. Here is a clear conflict with the DOT. ALJs, You should ask the VE for the basis for the opinion, then decide whether to accept it or rely on the DOT. Let's demonstrate how this might happen at a hearing. We'll drop in on a hearing in progress. Assume the VE has testified that the claimant cannot perform past work. The ALJ is now asking about other work at Step 5.
Ms. Ortiz, is there any other unskilled sedentary work that a person with this RFC could perform?
Yes, such an individual could perform the work of a switchboard operator. Now that's DOT number 235.662-022. It's unskilled sedentary work. Now the DOT defines this as semi-skilled work with an SVP of 3, but due to changes in technology and automation of many tasks since the occupation was classified, in my opinion, the work is now performed at the unskilled level.
So your testimony on this point conflicts with the information in the DOT. Can you explain the basis for your opinion?
Sure. I've stated the changes in the work requirements, and this is based on my experience in placing people in these jobs and studies of how the work is now performed.
You can see how this might have a profound effect on your decision. At Step 5, the position of switchboard operator might be other work the claimant could perform if it is defined as unskilled work. If a switchboard operator is found to be semi-skilled, you must address transferable skills, and it's much less likely this is the other work the claimant could perform. In fact, this change may even be relevant at Step 4. Consider a claimant who has past relevant work as a switchboard operator. Performed the work in the past at a semi-skilled level, but is now limited to performing only unskilled work. This claimant could not perform past relevant work as a switchboard operator as previously performed, but could perform the work as it is customarily performed, since the work is now classified as unskilled work by the VE. Another example is the position of telephone solicitor or telemarketer. The DOT defines this job as sedentary, semi-skilled work with an SVP of 3. Some VEs now find this to be unskilled work. It can be learned within 30 days, a hallmark of unskilled work. This is due primarily to technological changes, automation of scripts, and other changes in work requirements. Again, you must resolve the conflict between the VE testimony and the DOT and explain your reasoning in the decision.
Always ask the VE to explain the basis for an opinion that is in conflict with the DOT. Although not an exhaustive list, the opinion will most commonly be based on the VE's experience in job placement, career counseling, labor market surveys, knowledge of labor markets, publications, or information from other employers. ALJs, address this in your instructions. A brief note identifying the conflict and stating why you're accepting the VE testimony is sufficient. Attorneys and paralegals, you need to be attuned to this issue. It's part of the critical role you play as a legal advisor. If the VE testimony is consistent with the DOT, the Findings Integrated Template, or FIT, automatically generates the necessary statement. Make sure it remains in the draft. But check the instructions and the hearing notes to see if conflict was identified. If so, explain why the VE testimony or the DOT is accepted. A lengthy explanation is not necessary. A few concise sentences should suffice.
By the way, you generally should not assign weight to the VE opinion as you would a medical opinion. By the way, you should not assign weight to the VE opinion as you would a medical opinion. Modifiers such as great, some, and little are often used in describing the weight given to a medical opinion. We recommend that you not use these modifiers with a VE opinion. With rare exceptions, the VE opinion is either accepted or rejected. This is how it should be expressed in the decision. As a general practice, ALJ should ask for the DOT and SVP number of each occupation identified by the VE. Attorneys and paralegals should include this in the decision. Most importantly, if the VE identifies other work the individual can perform, you must include the number of jobs for each. Finally, attorneys and paralegals should double-check to ensure that the RFC finding in the decision is identical to that stated to the VE. We discussed this in an earlier broadcast, but it bears repeating. If they're not the same, it's a sure remand.
Let's return now to our discussion of conflicts with the DOT. You gave an example of work that devolved from semi-skilled to unskilled. Do you have another example where VE testimony might conflict with the DOT or the SCO?
Yes, the exertional requirements for an occupation may cover a range. An occupation defined in the DOT as medium exertion may also be performed in the national economy at the light or sedentary level. A good example of this is the position of hand packager, which is described in the DOT at 920-587.018 as unskilled medium work. A VE may testify that this work is also performed at light or sedentary exertion and offer the number of jobs at these levels. ALJs ask the VE to identify this conflict and provide a basis for the opinion. Remember, neither the VE nor the DOT trumps. The ALJ decides whether to accept the VE testimony or rely on the DOT.
Okay, those are two good examples where a conflict exists. It's patent. The DOT says one thing, the VE something different. What about a claimant who must change position regularly? Say, every half hour the claimant must stand and stretch briefly. Is this a conflict with the DOT?
An RFC that includes this limitation does not mean that the VE testimony will be in conflict with the DOT. Neither the DOT nor the SCO specifically address a sit-stand option. However, this additional limitation may eliminate some occupations that can be performed or reduce the number of jobs available. The DOT and its companion publications do not address the situation, and the SSRs do not give a complete answer. In fact, SSR 83-12 says that unskilled jobs are particularly structured so that a person cannot ordinarily sit or stand at will. SSR 96-9P provides that if an individual may need to alternate the required sitting of sedentary work by standing or walking periodically, if this cannot be accommodated by scheduled breaks and lunch, the occupational base is eroded. And remember that SSR 96-9P reminds you that the RFC assessment must be specific as to the frequency of the individual's need to alternate sitting and standing. So, if you include some version of a sit-stand option in the RFC, take special care with the VE testimony. For example, ask the VE if the limitation has been considered in determining the ability to perform and the number of jobs available at Step 5. Presumably, the VE considered this limitation in the expert opinion, but it helps to ask directly. You must also consider adding a few sentences in the decision to show it's been considered. For example, you might write, although a sit-stand limitation is not found in the DOT and therefore SSR 00-4P is not applicable, the VE testified that the representative occupations identified could be performed with this limitation, and I accept this testimony. There are other common situations where a claimant's RFC includes limitations not found in the DOT. For example, the DOT considers reaching limitations but does not specifically address overhead reaching alone. Likewise, the DOT considers bilateral manipulative limitations. It does not separate out limitations to only the dominant extremity. An RFC with these limitations is not strictly a conflict with the DOT. But to be safe, ensure that the VE has considered them in rendering an opinion.
The Office of the General Counsel has defended a number of appeals in recent years focused on the reasoning level required for certain jobs. Although it may not directly implicate SSR 004P, it's closely related. The issue arises when a representative argues that the claimant cannot perform jobs identified by the VE because the reasoning level required by the job is too high. That's the argument in a nutshell. Now let's look at it more closely and give you practical advice on how to handle it in your hearings and decision drafting.
First, what is a reasoning level? The source for reasoning level is in the DOT. The DOT defines each occupation using several categories, one of which is General Educational Development, or GED. Within the GED is the reasoning level required for the occupation. There are 6 possible reasoning levels. Most unskilled work in the DOT is at reasoning level 1 or 2. Level 1 is the lowest level. It requires a worker to apply common sense understanding, to carry out simple 1 or 2-step instructions, and deal with standard situations with only occasional variance. Level 2 requires a worker to apply common sense understanding, to carry out detailed but uninvolved written or oral instructions, and deal with problems involving a few concrete variables from standardized situations.
Now let's consider a common RFC in light of these 2 reasoning levels. Consider a younger claimant with a limited education who can perform the full range of medium work, but is further limited to performing 1 to 2-step tasks. The VE identifies representative unskilled work that such an individual can perform. On cross-examination, the VE admits that the occupations identified all require a reasoning level of 2. Can you see the problem? The RFC limited the claimant to 1 or 2-step tasks. Jobs at reasoning level 1 require an ability to carry out 1 to 2-step instructions. The occupations identified by the VE require a reasoning level of 2. The representative argues that the claimant cannot perform those occupations. The reasoning level required is too high.
So what's the answer? Quite simply, get clarification from the VE. First, ask whether the VE agrees that the RFC precludes the claimant from performing the reasoning level 2 jobs identified. You may find the explanation persuasive and rely upon it. But also ask the VE if there are any reasoning level 1 occupations that the claimant could perform. If so, this circumvents the objection.
The 11th Circuit recently addressed this issue in Leonard v. Commissioner of Social Security, 409 Federal Appendix 298, 11th Circuit, 2011. The court held that the VE resolved an apparent conflict between the claimant's RFC and the reasoning level for telemarketing. The court found that a telemarketing job was consistent with the claimant's limitations and that the VE had personal knowledge of that job, having worked as a telemarketer for 25 years. This case is an example of a court's acceptance of well-developed VE testimony. The hearing transcript is part of the record. The court sees all the testimony. And ALJ's thorough questioning and the VE's concise testimony makes it easy for us to show that the issues were properly considered and that evidence was properly developed.
From the perspective of the Appeals Council and the Office of the General Counsel, the key is to recognize and address the issue. If you ignore it, the courts won't permit us to provide post hoc justification. Remember, the standard of review at the court level is substantial evidence. An issue that is recognized and addressed at the hearing and in the decision is much more likely to survive appellate review.
We just examined a situation in which the representative addressed the objection to VE testimony at the hearing by means of cross-examination. This is the point of the hearing, to fully air and ultimately decide all relevant issues. Do not permit representatives to reserve objections to the VE testimony until after the hearing. In some instances, representatives may submit a pre-hearing memorandum seeking to reserve those objections post-hearing, or they may raise the point in the course of the hearing. Do not allow this. These issues should be addressed at the hearing. Certainly, if you wish, you may permit a post-hearing memorandum from the representative on any issue. But the hearing is the forum for raising objections, not some time later.
We've presented a few common scenarios where vocational evidence may conflict or is not addressed in the DOT. Be alert to these scenarios. They're not exhaustive, but cover most issues you're likely to see. Let's recap Key 2 with a few simple reminders. Always ask the VE if the testimony provided conflicts with the DOT. If you suspect a conflict the VE has overlooked, ask about it specifically. For all conflicts identified, ask the VE to state the basis for the opinion given. Determine whether the VE explanation is reasonable and provides a basis for relying on the testimony rather than the DOT. And explain the resolution in the decision.
Now let's turn to Key 3 and the subject of transferable skills. We'll introduce this with a short sketch and a few one-touch questions. In the sketch, assume a 42-year-old claimant with a high school education and past relevant work as an electrician, a skilled occupation. We'll join the hearing in progress. The ALJ is questioning V.E. Jones, whose qualifications have been established. In our one-touch question, we ask you in the audience to count the number of substantive errors in the questions asked. So listen closely.
Mr. Jones, can you classify the claimant's past relevant work?
Yeah, the claimant has a past relevant work as a construction electrician. This is a DOT code number 824.261-010. It's skilled work with an SVP of 7. It's customarily performed at the medium level of exertion.
Mr. Jones, would you identify the transferable skills the claimant acquired in this past work?
Yes, the transferable skills are analyzing, compiling, computing, and comparing data.
Assume a hypothetical individual of the same age, education, and work experience as the claimant. Assume further that this individual can perform the full range of light work, but must work primarily alone. Could such an individual perform the claimant's past work?
No.
Are there any other occupations such an individual could perform?
Yes, such an individual could perform the work of a calculating machine operator, which is sedentary, semi-skilled work with an SVP of 3. That DOT number is 216.482-022, and there are 290,000 such jobs nationally.
Thank you. Mr. Representative, do you have any questions?
No, Your Honor. I hope you listened closely and made some mental notes. How many errors did you find in the questions asked? A, 0 errors. B, 1 error. C, 2 errors. D, 3 errors. Or E, 4 errors. The answer is D, 3 errors. Let's look again at each error. The first occurs in the very first question by the ALJ.
Mr. Jones, can you classify the claimant's past relevant work?
The ALJ asked the VE to describe the claimant's past relevant work. The question should be, what is past work, not past relevant work. The ALJ decides whether past work is past relevant work, not the VE. Here's the second error. It's in the very next question.
Mr. Jones, would you identify the transferable skills the claimant acquired in this past work?
Do you see the error here? There is no need to ask the VE about transferable skills. It's immaterial at this point. If this younger claimant is able to perform any unskilled work that exists in sufficient numbers, the claim must be denied. There is no reason to complicate the vocational analysis by discussing transferable skills. And finally, the third error, the fatal error.
Are there any other occupations such an individual could perform?
Here, the ALJ asked the VE to identify any other occupations. She neglected to limit the question to other unskilled occupations. As a result, the the VE identify a semi-skilled occupation. The ALJ compounded her error by not asking what skills transferred and whether any other skills were needed to perform those occupations. These errors will result in a prompt and swift remand if appealed. The entire thicket could have been avoided if the ALJ asked for unskilled occupations only.
This introduces Key 3 of the 4 keys to vocational evidence. Key 3 says, transferable skills are usually not an issue. Do not assess unless necessary. Abandon all hope, you who enter here, reads the sign over the portal in Dante's Inferno. Recall this admonition before venturing into transferable skills. Of course, we exaggerate a little here, but the point is this. Transferable skills are not often an issue in decisions at the hearing level. ALJs don't ask about transferable skills unless it is an issue in the case. So, when must you get into transferable skills? In only 2 circumstances. 1, when the medical vocational guidelines or the regulations require it. And 2, in the very rare instance when the claimant's RFC precludes unskilled work but does not preclude semi-skilled or skilled work.
Let's try another one-touch question. Assume a 53-year-old claimant, a high school graduate with past relevant work as a high school biology teacher, a skilled occupation, performed at the light exertional level. Assume further that the claimant's RFC is limited to the full range of sedentary work. Therefore, the claimant cannot perform past relevant work. At the hearing, should the ALJ ask the VE to identify the transferable skills from this past work? Yes or no? The answer is yes. Do you see why? Under the medical vocational guidelines, if this individual has no transferable skills, Rule 201.10 or 201.12 directs a finding of disabled. If there are transferable skills to semi-skilled or skilled work that could be performed, Rule 201.15 directs a finding of not disabled.
Let's consider another one-touch question. Assume a 57-year-old claimant, a high school graduate with past relevant work as a construction electrician, a skilled occupation, performed at the medium exertional level. Assume further that the claimant's RFC is limited to the full range of light work. Therefore, the claimant cannot perform past relevant work. At the hearing, should the ALJ ask the VE to identify the transferable skills from this past work? Yes or no? The answer, again, is yes. If this individual has no transferable skills, a finding of disabled is directed by Rule 202.06. If there are transferable skills to semi-skilled or skilled work that could be performed, Rules 202.06 or 202.07 direct a finding of not disabled. Our one-touch questions highlighted circumstances under the medical vocational guidelines when transferable skills might be an issue. They are a claimant closely approaching advanced age or older who is limited to sedentary exertion and cannot perform past relevant work, and a claimant of advanced age or older who is limited to light work and cannot perform past relevant work. The upshot is this. With very rare exceptions, if the claimant is under age 50, transferable skills are never a material issue. Therefore, if the claimant is a younger individual, do not ask about transferable skills at the hearing or consider them in drafting a decision.
We mentioned there is a rare exception to this rule of thumb. So what is it? Well, it's the second situation we mentioned earlier. It happens when, based on VE testimony, you conclude that the claimant's RFC precludes unskilled work but may not preclude semi-skilled or skilled work. That's a mouthful, so let's break it down with an illustration. Unskilled work often permits an employee less freedom than skilled work. For example, the freedom to take short breaks, to change position, or to change tasks is generally much more constricted for unskilled work. An individual's RFC may require some liberality in breaks, working position, or tasks, and the VE may opine that there are no unskilled jobs for such a person. However, there may be semi-skilled or skilled work this person could do. In this admittedly rare situation, transferable skills are an issue. Remember also that transferable skills can only come into play at step 5 of the sequential evaluation process, when you are considering other work the claimant may perform. If you must get into transferable skills, there is a roadmap. If you must, just as Dante described 9 circles, we have 9 steps to transferable skills to guide you on your journey. It's a one-page primer authored by former Chief Judge Cristado, and it describes each of the steps you must follow to properly evaluate transferable skills. We've posted a copy on the OSEP website. A discussion of the 9 steps to transferable skills is beyond the scope of this broadcast. In short, you cannot find a claimant can do other semi-skilled or skilled work at step 5 unless you have VE evidence. The grid rules alone are not sufficient. The VE must specifically identify the skills acquired in claimant's past relevant work. Those skills must directly transfer to the other work, and the other work must require no other skills.
Since this is a highly technical area, ALJ should closely adhere to a script for asking questions when transferable skills are an issue. It's very easy to get lost in the thicket. The instructions and decision must specifically identify the skills transferred as well. Attorneys and paralegals should be thoroughly familiar with the prerequisites to finding transferable skills so the decision is properly drafted. But remember, most decisions do not require an evaluation of transferable skills. Do not assess transferable skills unless necessary.
Let's summarize Key 3 with a few rules of thumb. 1. Transferable skills are not an issue with younger claimants, with very rare exceptions. 2. Do not ask the VE to identify transferable skills unless it's a material issue. It rarely is. And 3. Initially, ask the VE to identify only unskilled work when asking about other work at Step 5. This brings us to the final part of our program. Now we'll examine how to elicit VE testimony and handle common objections. We'll introduce this topic with Key 4. Key 4 says, examination of the VE is limited to pertinent questions on material issues. The ALJ should determine the appropriateness of the questions asked and the answers given. As you see, Key 4 is a very general statement, but it is the overriding principle that governs questioning of the VE by the ALJ and representative or claimant. Testimony of a VE is addressed in the regulations at 20 CFR sections 404.1566E and 416.966E, and the Hearings, Appeals, and Litigation Law Manual, or HALEX, I-2-6-74.
Did you know that under HALEX, the VE may attend the entire hearing, but is not required to do so? If the VE is not present during pertinent testimony, for example on past work or educational background, the ALJ must summarize this testimony for the VE on the record. Some ALJs begin the hearing with the VE present and elicit testimony on the claimant's employment history and education, then excuse the VE from the hearing until VE testimony is required. If you do this, ask the representative or claimant if there is any objection. There shouldn't be. It's entirely within your discretion as ALJ to do this.
Key 4 focuses on VE testimony and objections by representatives or claimants. In essence, there are only 2 objections that can be raised to VE testimony. 1. Objections to the qualifications of the VE, and 2. Objections to the opinion of the VE. Let's look first at the expert qualifications issue. The VE is an expert witness, of course. So with any expert in any legal proceeding, the VE's qualifications to provide expert testimony must be established in the record. You generally do this by including the VE's statement of qualifications as an exhibit in the file. This should be an exhibit in every file. As part of the preliminary questioning of the VE, the ALJ should ask if the exhibit is an accurate statement of the VE's qualifications. If this statement is not in the record, the ALJ must establish the qualifications in preliminary questioning of the VE.
Once the qualifications are established, either in an exhibit or through testimony, the ALJ should ask the representative or claimant, "Do you have any objection to the qualifications of this individual to testify as a VE in this hearing?" In the overwhelming number of cases, no objection is raised. If an objection is raised, you should ask for the basis of the objection. You may also permit limited voir dire or questioning of the VE by the representative or claimant. Then rule on the objection. You can reserve decision and rule later on the objection, but in most instances you should rule immediately. If you deny the objection, you have found the VE qualified to render expert opinion and may proceed with the testimony. For clarity in the record and efficiency in the hearing, it is critical that the ALJ separate objections to the qualifications of the VE from objections to the opinion of the VE. Resolve the qualifications issue at the outset. If you followed these steps, the VE is qualified as an expert, and the only potential objections remaining must relate to the VE's opinions.
Let's turn our attention now to objections to the opinions of the VE. We'll first discuss the permissible scope of cross-examination by representatives and claimants, and then look at how to address objections to the opinions. Both HALEX and the regulations provide useful guidance. Regarding VE testimony, HALEX I-2-6-74 instructs the ALJ to ask questions to elicit clear and complete information, allow the claimant and representative to fully question on any pertinent matter within VE expertise, and determine the appropriateness of any questions asked or answers given. The regulations permit the admission of evidence on any matter material to the issues. Therefore, in determining the permissible scope of examination, be guided by a simple principle. The questioning must be pertinent to a material issue. Don't permit the questioning to go too far afield with no apparent focus or direction. If the questioning is off track, the ALJ should intervene. Ask the representative to explain the purpose of the line of questions. If it is not leading to a material issue, direct the questioning to another topic.
To be clear, the cornerstone of due process is the hearing. The claimant and representative have the right to question the VE on any pertinent matter within the VE's area of expertise. Relaxed standards of evidence govern our hearings to allow for a full presentation on the issues. This does not mean that no rules apply. The hearings are not a free-for-all where anything goes. ALJs, you should be vigilant in assuring that the subject and scope of examination by the representative or claimant is pertinent. You control the hearing.
If the representative poses an improper question, the ALJ should not permit the VE to answer. The ALJ should advise the representative why the question is improper and, if necessary, direct the representative to pursue another topic. Let's look at a few examples of questions you should not permit a VE to answer and explain why. Here's a question a representative occasionally asks. Do the jobs you identified exist in the immediate area where the claimant lives? Judge Goldstein, why should you direct the VE not to answer this?
20 CFR 404.1566A and 416.966A covers this. It is not proper because disability is based on whether work exists in the national economy, as we noted earlier. In addition, disability is not based on unemployment due to lack of work in your local area.
How about this question? Do specific job vacancies exist for the jobs identified?
The same regulation applies. An inability to obtain work lack of job openings, and whether the claimant would be hired is not a basis for disability.
What's wrong with this question? Would someone with a felony record be hired for that job?
The same regulation applies here too. A criminal record is not relevant to whether an individual can perform the physical and mental basic work activities for a particular occupation.
We often hear this question: if the claimant's testimony is accepted, are there any jobs the claimant could do?
This is not proper because the VE should not be asked to interpret the claimant's testimony and draw conclusions.
Finally, this question: could a person with moderate limitations in concentration perform the jobs identified?
We addressed this specific issue in an earlier OSEP broadcast on residual functional capacity. The limitation in concentration must be expressed in functional terms. Moderate does not describe how the claimant is functionally limited.
These are but a few common examples. For any question asked by the representative or claimant, make sure it is pertinent and is directed toward a material issue. Let's look at how to handle objections to a VE opinion.
Halleck's I-2-6-74 expresses a common sense rule and says the ALJ must rule on any objection. The ruling may be on the record, in a writing added as an exhibit, or addressed in the body of the decision. ALJs, if you reserve decision on an objection at the hearing, make sure you rule on it later in writing or in the decision.
Occasionally, we see cases at the district court level in which a representative challenges the foundation for the VE's case-specific opinion. You should recognize that your hearing is not governed by the federal rules of evidence. The standards for qualifying an expert in a federal court trial established by the case Dobert v. Merrill Dow Pharmaceuticals, 509 U.S. 579, 1993, do not apply to our administrative proceedings. The VE's recognized expertise usually provides the necessary foundation for the VE's opinion testimony. The ALJ has already established this at the outset of VE testimony. If, under questioning, the VE can identify the sources consulted to support the testimony given, this should be sufficient.
ALJs should take a practical approach to these objections. Allow pertinent cross-examination and entertain the arguments of the representative or submission of a post-hearing brief. Then rule on the objection at the hearing or address it in the decision.
Occasionally, representatives will challenge testimony on the number of jobs. Understand this: the Appeals Council or federal court rarely remand cases on this issue. Recognize that testimony on the number of jobs is an estimate. The VE can base this estimate on reliable job information in various governmental and other publications of which we take administrative notice under 20 CFR sections 404.1566 and 416.966. In addition, the opinion may be based on the VE's knowledge and experience or other explanation the ALJ deems reasonable. So permit questioning, of course, but make sure it remains focused.
Here's a tip that you should consider in all hearings. With very rare exceptions, an estimate of the number of jobs nationally is sufficient. There is no need for testimony on the number of jobs regionally. This is so because 20 CFR sections 404.1566 and 416.966 say there must be a significant number of jobs in the region where the claimant lives or in several other regions of the country. National numbers almost always embrace several regions, so the national number of jobs will be sufficient. Remember, an isolated job that exists in very limited numbers in few locations outside the region where the claimant lives is not considered work that exists in the national economy. An example might be the job of a clam digger, which exists in only a few locations. If the VE testified that this is a representative occupation for a claimant living in Arizona, you might want to ask for other representative occupations. Obviously, this is rare. The simple step of asking for only national job numbers will streamline your analysis as ALJ and eliminate a potential line of questions by the representative on the number of regional jobs.
If a challenge is raised to the number of jobs testified to by the VE, remember a few basic facts. We take administrative notice of reliable job information from various governmental and other publications listed at 20 CFR sections 404.1566D and 416.966D. The VE uses this information in conjunction with other publications and renders an opinion as a qualified expert on the number of jobs available. The number of jobs is an estimate, not an exact number. Your job as an ALJ is to determine, based on the explanation by the VE, whether to accept the testimony. In most cases, sufficient support for the estimate will be apparent. If you're not satisfied, remember that this is a representative occupation. Ask the VE if there are other representative occupations that an individual with the stated RFC could perform.
What about production of documents by the VE? Occasionally, a representative objects to a VE opinion and requests production of documents by the VE. For example, the representative may ask for production of labor market surveys or publications created or used in the VE's professional capacity. Nothing in the Social Security law, regulations, or HALEX requires the VE to produce this material. Remember, the VE generally relies upon publications identified in the regulations and other publications available to the public. Certainly, the VE may be questioned on the basis for the expert opinion, but it's hard to imagine a circumstance where the ALJ should grant the request for production of documents by the VE. If you do, make sure the document is pertinent to a material issue.
In sum, ALJs, you control the conduct of the hearing and the scope of questioning. If questioning of the VE gets off track or far afield, rein it in. Ensure that it is focused on a material issue. Don't hesitate to ask where the questioning is leading. If appropriate, allow for a post-hearing argument to be submitted by memorandum. Now we'll turn to Judge Costello for a few final remarks.
Thank you, Judge Griswold. We've addressed some sophisticated topics today. But Leonardo da Vinci once said, "Simplicity is the ultimate sophistication." In modern parlance, we say KISS. Keep it short and simple. This should be your guiding principle in conducting hearings and drafting decisions on these issues. Control the hearing, focus on the real issue, and address it succinctly in your decision. We conclude our program with the 4 keys to vocational evidence. Most adult disability cases require VE evidence. 2. No SSR 004P. Address conflicts with the DOT. 3. Transferable skills are usually not an issue. Do not assess unless necessary. And 4. Examination of the VE is limited to pertinent questions on material issues. The ALJ should determine the appropriateness of questions asked and answers given. Thank you for your attention and participation today. We hope you found the program informative and helpful.
Using the keypad, please rate the overall broadcast on a scale of A through E, with A being excellent, C average, and E poor. When complete, please press the next key. Question 2. From the following list of 5 possible responses, what is the one thing you liked best about the broadcast? A. Organization of the content. B. The presenter's delivery. C. The length of the broadcast. D. The interaction and/or keypad questions. Or E. The examples. When complete, press the next key. Question 3. Once more, from a list of 5 possible responses, what one thing would you most like to change about this broadcast? A, organization of the content. B, the use of graphics and other visual aids. C, have more examples. D, more interaction and/or keypad questions. Or E, no changes are needed. When complete, again, press the next key. And finally, question 4. How worthwhile was this broadcast to you? Was it A, very worthwhile, B, worthwhile, C, the content was insufficient, D, you already knew the content, or E, the content was not relevant to your job? When you press the next key, you'll get the question, exam completed? Answer yes, and your evaluation will be recorded. Thank you for your participation.